Yes, sir. Kamesh,
Yes, sir.
we can
Okay,
start.
sir.
Kamesh, start.
Should I start? Okay, sir.
Start.
Just a second, sir. Okay, screen is being recorded. Very good afternoon and warm and heartily welcome to our director, S. Shambhu Prasad, sir, Vice President, Mr. Satish Meka, sir, our principal, K. Satyanarayan, sir, Vice Principal, Dr. G. Naresh, sir, our resource person, Mr. Govind Sharma, sir, our coordinator, Dr. Subodh Panda, sir, and faculty coordinators, management staff, technical staff, student coordinators, and students. I would like to welcome you all to the webinar on this topic, importance of intellectual property right. Myself, Kameshwar Shastri of second year mechanical at Pragati Engineering College. I would like to welcome our coordinator, Dr. Subodh Panda, sir, for welcoming in this gathering. Sir, please. Subodh Panda, sir.
Otherwise, Kamesh, you carry on. Not an issue.
Okay, sir. I would like to introduce and welcome our resource person, Mr. Govind Sharma, registered patent agent, ex-chief at National Research Development Corporation, New Delhi. Sir has pursued Masters in Science in Chemistry from University of Rajasthan and a Master of Engineering in Polymers from Delhi University of Delhi College of Engineering. He has worked with NRDC for 33 years. He has dedicated his services and applied his knowledge in identification, sourcing, evaluation, development, monitoring, and transfer of technologies, organizing skill development programs, filing and implementation of patents, handling personal and administration activities. After 33 years of his service in NRDC, he retired as chief. He was well known for his work on the projects where he was appointed as project in charge. He worked with some well-known institutes like IIT Kharagpur in advising and in supervising. He has, with his ongoing enthusiasm for sharing his knowledge, even took the job role of guest faculty in various well-known institutes. Sir has been awarded the IPA award for most talented HRs in PSUs. Sir has many more achievements and experiences from foreign visits to memberships. Sir, the stage is open for you, please. Sir?
Shall I start?
Yes, sir. Please.
Shall I start?
Yes, sir.
Yes, sir. Please continue.
Okay. Okay. So good afternoon to all the participants, and I extend my greetings on World Intellectual Property Day to all of you. Friends, the theme of World Intellectual Property Day 2022 is IP and Youth Innovation for a Better Future. Events organized to mark the day seek to inform about the role of intellectual property rights in encouraging innovation and creativity. For 2022, the theme will explore how youth are driving positive change. The annual review international patent system administered by WIPO claimed that only 6% PCT application originating from India were filed by universities in 2018. This implies that young researchers need to know more about IP rules and right. With the increasing focus on innovation, research, and cross-border collaboration, need to learn about IPR to safeguard their invention has increased among the students. As India turned to innovation and creativity for sustainable development, need to understand importance of IPR has increased. The demand for IP is increasing, especially in developing countries. The IPR ecosystem in non-premier institutes across the country needs prolonged effort to make students aware of the importance of IPR and filing procedures. The academic community needs a higher level sensitization and exposure to patenting and technology commercialization. All academics and research institutions should also develop in-house expertise for assessment and filing of provisional patent application as well as commercialization of patented technologies. Friends, The God has given us a wonderful thing called brain or the mind. Mother Earth has given us enormous natural resources. We are bestowed with one more thing that is called creativity. So in the past, we applied our mind on the natural resources using our creativity. We made several articles for our convenience and comfort. But unfortunate part is all these things, all these creations, they were in the public domain, and the people could use all these creativity without any restriction, unrestrictedly, without making any payment. So the governments all over the world at the end of the 18th, 19th century thought, why should we not give ownership right of this creation to the creator? Because once the ownership right is given, you can control the use, making and sale of your creativity. Like you have a house is also called a physical property. Suppose a house is registered in your name, you can control the use, you can license it, you can give it on rent, you can sell it, you can use, you can keep it for self use. So like that, all the government thought that let us give the ownership right. That means once the ownership right is given to you, you will decide who will use your intellectual property, who will use your creativity. So it has a very high commercial importance. And immediately after independence, when our constitution was formed, in our constitution, the makers of the constitution have given power to the parliament to enact the laws related to copyright, patent, design, and trademark, etc. With this power in the parliament, our parliament has enacted several laws related to IPR Act. For example, the Patent Act 1970, which was amended in 2005. Then we have a Trademark Act, Copyright Act, again amended in 2012. Design Act we have, then Geographical Indication Act of Goods Act 1999, relatively a new act. Semiconductor Integrated Circuit Layout Design Act 2000, Protection of Plant Varieties and Farmers' Right Act 2001, and the Biological Diversity Act. All these laws has been enacted by our parliament. The purpose for enacting all these laws is that they want to give some incentive and they want to encourage inventivity, creativity in the country. So what was happening earlier, that you create and others were using without recognizing your authority on the your creation. So if the government gives you the monopolistic right, not for the always, for a limited period, then it encourages others also, because you know that if you create something, there is a government that will protect your right and you can make business using your creativity. So earlier it was not there, the people were not creating much, but now you see a lot of patents, a lot of intellectual property, and a lot of industries, a lot of businesses are coming up based on the intellectual property. So this protection, when this act were enacted for the protection of intellectual property, uh, so many businesses have come up, and it has encouraged many people, both young, old, women, everybody. They have these laws have actually encouraged to protect, to create more innovations and protecting them through some intellectual property tool and make earnings out of that. If you see, if you sit down on the computer, Google, and see the definition of intellectual property, you will find thousands of definition of intellectual properties. Some of them even I don't understand. But this is my definition of intellectual property. I call intellectual property as a mental tradable product of mind. That means whatever you create, it must be linked with the commerce or with the revenue generation. So that's why I call it a tradable product of mind. So the next question comes, why, what is the rationale behind it? Why should we protect our creation? Well, the reason being that the creator always effort, money, time, they invest time, efforts, and money for creating something. So they must get due reward for their creations. And secondly, it encourages people to invest in this way because people know that there is a act, and if they create something, that will be protected, and that will be protected by the government. And thirdly, the people who create, they don't use their creation, but the entire society is benefited by their creation. For example, somebody created a medicine called paracetamol, which is used for pain management. But do you think the person who developed the paracetamol is alone using the paracetamol for himself? No, the entire society, when there's a pain in us, we go and buy paracetamol. So with your creations, entire society is benefited. Why do startup now? You may be some startup or some entrepreneurs may be there in your this workshop. So why do startup protect their ideas? One reason being, if you protect, you get protection against the competitor directly copying the idea. Once you are protecting your intellectual property, once you are protected your creation, your competitor will not copy it, because these laws are very stringent. You can drag him into the court of law. You can put him behind the bar. You can put financial penalties on him. So once a protection is given to you, your competitor will not directly copy it. He will afraid. Then help business maintain their long-term competitive edge, because all these intellectual property, they have a lifetime. For example, patent is valid for 20 years. So for you are sure that at least for next 20 years, nobody is going to copy your patent. Then the registered IP is an asset. The asset means now see when you make in your annual report, you have to write what are the assets you have. Every year, your institution may be having an annual report. In your annual report, you mention what assets you have. So you will show your building, your television set you have, laboratory equipments, and your and tube lights, air conditioners, tables, chairs, and so many other things you mentioned there. So your 95% content is the physical property. I had a chance to go through the annual report of Microsoft. I was surprised to note that the 80% asset was in the form of intellectual property and 20% was the physical property. Whereas in our country, 80 to 90% is the physical property and 10% is the intellectual property. See how it is changing. So it is an asset in the sense, in some countries, some oriental countries like Japan and Korea, like suppose you need money, you can mortgage your house. Similarly, in those countries, in oriental some countries, if you have a IP, you can mortgage IP and get the money, get the loan for doing your business. Now this give a consumer's confidence also. For like people like me, if some company is innovative, they bring out some new product, or they protect their product, I buy, because I have a confidence that this company must be selling the genuine product. Therefore, it creates a confidence among the consumers, then enable entrepreneurs to license. For example, if you create intellectual property, you don't want to use it yourself, you don't want to set up an enterprise based on your creation, based on your intellectual property, then there are the people in the market who can buy, or you can license. You can license your intellectual property. License means permission. You can give permission to them for some particular period of time to use your intellectual property. So intellectual property has so much of advantage today nowadays. Now, uh, let us see the categories of intellectual property. These are the 9 categories of the intellectual property. It can be further classified into 2. The one is the copyright and related right. Copyright and related right. Next 8 are come under industrial property. First is the copyright and related right, and rest are the industrial property. So these are the 9 kind of intellectual property which we are dealing every day. But which we are dealing now, the ninth one, utility model, is not there is no law, there is no act for the utility model in India. Hopefully in future the law will come. So let us see them. What are the one by one? What are they? The copyright actually protects the expression of idea. That means idea are never protectable. In no country idea is not protectable, but you have to fix the idea into some medium. Then medium is protected. For example, somebody wrote a story, so he write a story. Story is protectable as a copyright, and somebody make a film on that story. That film is also protectable under copyright. Somebody write a lyric, a song, a lyric is written, and the lyric is protected as a copyright under the name of lyricist. And somebody comes and give a music to it. The music director, then he convert it into a music. Then music is also protected under copyright. And somebody comes and choreograph this music, then choreographer also get the protection under copyright for the choreography. So now you see in one thing how many protections one can give. So this protection of this copyright is provided to the author of original work, What kind of work are protectable under copyright? The literary work, that means if you write a book, or if you draw a picture, you draw a story, artistic works, if you make a sculpture, and scientific work, that means a write-up, scientific write-ups, they are protectable under this copyright. Then they extend to protect computer software, also protectable under copyright in India. Then the neighboring rights are recorded to, like phonogram producer, the performers, one who performs, the singer, and the broadcasting organization, the people who broadcast the films and the songs and the drama on television, on radio, they are also protectable under the Copyright Act. So this was brought in 2012. Otherwise, the neighboring rights were not there earlier. The protection is also very long, as long as the author survive, and 60 years after death of the author is also protectable. So who gets the royalty? Who gets the benefit after for the next 60 years? The legal heir. For example, some person has a house and he dies. His legal heir becomes the owner of the house. Similarly, somebody has a copyright and he dies. Then for next 60 years, her legal heir becomes the owner of the copyrighted material. So all the benefits, that is the royalty, the sale, whatever is obtained after selling the material, is given to the legal heir. Now, what are the products which you can, what are the things you can protect under copyright? Novel, poem, photograph, movie, lyrics, song, like that. Then you can protect computer software, software code for programming, so all kind of computing material that is protectable, but not they are not protectable under patent. Computer software per se. If there is computer software only, then it is protectable under copyright. If you have developed a hardware which is operated by a particular computer software, which is operated by a particular software, and the software is made only for that hardware, then hardware and software both you can protect under patents. Otherwise, your this is protectable under copyright. Now you might have seen this word C. That means it's a warning. It's a warning to us. If somebody has a copyrighted material, that means the warning is that don't copy it. The right of copy, performance, and display is with me. If you copy it, I'll sue you in the court of law. So this kind of things, this kind of sign or symbol they put after the copyrighted material. Now next is the patent. Patent is given for the invention. Patent is also a monopoly. All intellectual properties are monopoly rights. But monopoly is not always for a limited period. You have seen in copyright case, now patent is given, patent is also a monopoly right. Who gives all these rights? Government. In India, government of India gives. If you go to China, government of China will give. So it is granted by the government. When the government gives, when you disclose your creation in full, when you disclose your innovation, or when you disclose your creation, here invention in full to the government, and to whom it is given? To the owner, that means the inventor. And if the inventor is working in some organization, then his organization is given the patent as a assignee, and his name as an inventor is also mentioned in the patent. That is given for 20 years. It's a territorial right. Territorial right means you can enforce your patent only in India. If somebody copies your patent in other country, you cannot stop them. You cannot drag him onto the court of law. But you can, if somebody copies, for example, in China, and if he imports the material from China based on your invention, then yes, you can stop the import by complaining to the custom department. Now, what are the requirements for a patent? How you patent is given to you? The invention must relate to a process or a product. The patent is granted to a article, a product, or a machine, or a process. So invention must relate to a process or a product, or both also. Suppose you invent altogether a new product by a new process, then the product and process both are patentable. If you developed a process for existing product, the product was already there, but you have developed a new process, particularly in chemistry and biology and pharmaceutical science, they developed a new process, then only the protection will be given to the process, new process, not for the product. But what kind of invention should be there? It should be new. New means absolute new. That means it is not known to anybody anywhere in the world. Though the protection is given in India, but your invention should not be known to anybody anywhere in the world. Because when you submit an application to patent office for for patent, then the patent examiner of patents, he sees, he sit down on the computer and see various databases, and if if such a product is already available anywhere in the world. If it is available anywhere in the world, he will not grant you the patent. He will grant you the patent if it is novel. That means absolute novelty, nobody knows it. Involve a inventive step. That means human intervention should be there. That means something you bring from the nature and which is not known to anybody in the world, and you cannot claim it as your invention. It is a discovery of nature. And if you further work on the discovered product, and you make it useful for performing some duties, some functions, in that case you can get the patent on the modified natural the discovery. So, and the other requirement is the product of your invention must be capable of use in industry and can be produced in the industry. Then it is the application which you submit with the patent office must fully disclose the patent document. And the lastly, it should not be barred by section 3, 4, and 5 of the Patent Act. What is section 3, 4, and 5 of the Patent Act? Actually, in section 3, 4, 5 of the Patent Act, some products are given, some kind of inventions are given which are not patentable. For example, the mathematical formula, the mathematical equation, algorithms, and the theories, discoveries, they are not patentable. Something which is against the social order. Suppose you developed a new process for manufacturing atom bomb, altogether new product, it is not patentable, but because it is the thing of mass destruction. Similarly, the methods of treatment of plant and animals, they are not protectable. Diagnostic methods are not patentable. So there are some more things are there, but they are some of the common things which I have shown you. Another, with the help of this slide, I want to show you that for getting a patent, you need not to do any great invention. You need not to do any rocket science. You need not to have any higher degree from Massachusetts or from IITs. Even a school dropout, I've seen, because I've helped them filing a school dropouts, ninth class pass, because the idea can come in anybody's mind. The idea is not owned by anyone. The idea which comes to your mind can come to some other person anywhere in the world, any location, anywhere in the world. The same idea can come to that person also. But the person who takes the immediate action and get it protected is the real winner. Okay, so whenever some idea comes to you, don't discuss your idea with your colleagues. Suppose your colleagues find your idea workable, very good, he will use your idea and put the product in the marketplace before you, then you cannot do anything. So whenever the idea comes to you, file a provisional patent, or file a patent, so that once you file the patent, then granting and not granting is a later issue. Once you file a patent, the protection is granted from the date of filing of the invention. The moment you file a patent application, from next day you can disclose it, you can publish it, you can use it. Nobody can question. Now, this is the very simple. I want to tell you that even the simplest things are patentable. See, this is called paper clip. This paper clip you must be using in your office. In your office, it is very common. The paper clip is used for holding the paper, for to tag the papers is used. What is this? It is basically a simple steel wire which is turned into U shape or triangular shape two times, and then third time again it is folded and it becomes a paper clip which can hold the paper. So this was first patented in 1866. Thereafter, I want to tell you that if somebody has already patented something, invention, yes, you can do improvement on that, and those improvement can be patented in your name. So this invention was done in 1867. Thereafter, 64 times the improvement have been made, and 64 patents have been filed on this one single invention, which is the most simple invention. And last time in 2012, by this He Wang, a Chinese, has filed has been granted an American patent on it. And what is the improvement? His invention he claims that his invention can hold thick piles of paper. Now, I want to give you another example of this is a anyway up cup. This is very simple. See, for making an invention, what you need to identify a problem that needs a solution. If you want to make an invention, because you are traveling, you are moving all the time, you are moving in the market, in the house, and the friends places. You have to identify a problem, and that needs a solution, and then find a unique solution to that problem. Then you are able to get a patent on it. So here I'll give an example. This lady you see, her name is Maddie Haberson. She's a British lady. She is having 3 kids. One fine evening, she was invited by one of her friend for some dinner, and she went there, and her friend offered a glass of blackcurrant juice to her daughter, and the glass fell down, and his cream color carpet was spoiled. See, the moment they spoiled, and she has to cut a sorry figure, because sometimes the people feel that you don't teach good, I think, good habits to your children. So she felt very shy. That means she has to cut a sorry figure. The idea came from there. See, she identified a problem. What is the problem? Identification problem, because this problem is with every kid. Every kid used to fell the glass on the floor. So this is a general problem, and she identified a problem. She started working on it, and she find a solution which was not available anywhere in the world. She finds a solution in the form of this cup, and this cup is known, and there is a mouthpiece. There is a special valve. When when the children suck or the press the mouth of this cup, the liquid start flowing. When they release the pressure, the flow of liquid stops. So this is the first non-spill sippy cup in the world. Okay. Now see, she is not a technocrat. She is never going to. She's a housewife. She's mompreneur, the mother who become an entrepreneur. She has sold 100 million of such product in the market, and she has earned 100 millions of dollars also. She has earned, and she has been awarded as the uh, best entrepreneur of Britain in 2000. Now, this see, she identified a problem, find a solution, and she got a patent for it. Now, I want to show you another. This is the most ridiculous invention. Flatulence deodorizer. You can't stop people releasing gas. Sometimes the gas has the foul smell. So what to do? It caused a lot of problem for the people in the surroundings and for the person himself also. He has also to cut a sorry figure. See now what the inventor has done. There is a US patent on it. What the inventor in 2000 the patent has been granted. What the inventor did, you see, there is activated carbon. Activated carbon has a property that it can absorb colors and the foul gases. So what he put the activated carbon into a pad. He made a pad filled with activated carbon, and that pad can be wear with the in a particular place. It is where one can wear it with the undergarment, and now you are free. You can release the air, no problem. Everybody is happy. Now the things doesn't stop here. It is commercialized. The Amazon.com in America, he's selling this flatulence deodorizer disposable 3-day supplies. Every day you can use one. One is enough every day. And he see the product is such a wonderful product. He has got 5 star out of 5, 5.0 out of 5 stars. And the price is $89.95 for 30 and 16 are left. See, there is a market for this also. Someone identified a problem that this is a common problem with everybody anywhere in the world. So this is how the people how the people create. Now, next intellectual property is the industrial design. See, people generally 70 to 80% product are sold by the shape and the his appearance. How a product appear, people buy, because if something pleases your eyes, you go and buy in the market. This is a water bottle. I have this kind of water bottle, and I drink water from it. I like it. I bought it. There are other shapes of bottle also. The function of water, the nature of water doesn't change where in whatever bottle you. So it is not a functional design. Basically, industrial design are not a functional design. They are the physical appearance. How a product look like to your eyes, particularly the garments, the jewelries, and the bangles, and so many other things. They are available in the market. And you see the saris, the pocha, you are from Andhra Pradesh, the Pochampalli sari, the various designs, they all are protected by the industrial design registration. So the things how they appear, the appearance is also protectable. Let us understand with the help of an example that these are different kind of chairs. All these chairs are just used to sit, but it all depend. You may like a different design of chair. I may like a different design of chair. The price may be different, but the chair is a chair that is only used to sit. So this is also protectable for up to 15 years. First, in first instance, when you registered, and if your design is found novel, it is protected for 5 years. Then five next for 10 years you can uh, renew it for 2 times, for 5 years and 5 years. That means up to 15 years. What happen after 15 years? After 15 years, it comes in the public domain. Then anybody can use your design and can do business. You can't stop him. See, this is a design. I call it as a hug chair. This design has been created by a Bulgarian designer, Ilian Milinov. So, if somebody having his wife or the girlfriend very bulky, and he want to make love, he wants to lift her in arms. So he can use this design, and he can make love with her. So this is the design I call it as a hug chair. This design has been created by a Bulgarian designer, Ilian Milinov. So this is the design I call it as a hug chair.
Hello, sir. It is not audible, sir.
Sir, your voice is not audible, sir. Govind Sharma, sir, your voice is not audible, sir. Dear participants, please wait. Sir will be joining in a few minutes.
Hello.
Sir,
You are audible.
Yes, sir.
How long? You should have told me in the beginning if I am not audible.
No, no, sir. Just now you have not been audible.
Okay, okay. It was just now. Okay, thank you.
Yes.
So the industrial design. I think you all heard about industrial design.
Yes, sir. We did.
Yes, sir.
Yes,
From
sir.
which
Yes,
line
sir.
we got
Okay.
this?
You see, there are the various designs also for this music systems. You see the chair, the car. All car have different design. The function is same. All the car have the same engines, but the designs are different. Some people want some other different design, and they buy it. Similarly, the mobile phones. Mobile phones has a different design. People, it is all the personal preference which kind of mobile phone somebody wants. The next intellectual property is the trademark. Trademark is a intellectual property with the help of the trademark, you can identify the product of a company. For example, there are 6 television, and on all the televisions, some different stickers are there. Some has Sony, some has LG, some has Samsung, Philips. So you can immediately identify that it is Sony, this is Samsung, this is Philips. So trademark are basically the identification mark. You identify a good or service by seeing a trademark. Like Sony, S-O-N-Y, Sony is written. You don't see at the back of the machine that from where it is manufactured, where it is come. You just see the trademark Sony. So Sony, so all the trademarks, when you start a company, you must have a trademark also, because you are known by the trademark, and over the period of time, the trademark become the quality symbol. For example, among all the television, so Sony is preferred by the people because they know that if it is Sony, it must be good. A quality and reliability thing is there in the mind of the people, that the Sony products are good. Though the other products are similar, and for that Sony product, because of the brand value or because of the trademark, they give more price. They give 5,000 rupees more, because they are sure if they buy Sony, they buy a best product. So the trademark is protectable only for 10 years, and thereafter you can protect as long as you want. Initially for 10 years, for after every 10 years, you have to renew the trademark. If somebody imitate, you might have seen in Andhra Pradesh, Andhra also someday in the newspaper, you must be seeing some advertisement that uh, be aware of the copiers. We are the manufacturer of this, and some people are copying our this thing. Our trademark is this, so you buy the product by seeing this trademark. So like that, if somebody, I told you now, all these law has the teeth. If somebody use your intellectual property without your permission, without your licensing, then you can drag them into the court of law, and you can get the punishment for them. Both the it's a criminal and civil punishment, both you can uh, do for them. So now they are some of the important trademark: the Google, the Time, the Tide, Coca-Cola. These are some important trademark. They are all sub trademark. Now next is the geographical indication. Geographical indication, again, a very good intellectual property. See, I think you are from Andhra Pradesh. Hello.
Yes, sir. Yes, sir.
Ah. So Andhra Pradesh, there is a Pochampalli sari. So that means Pochampalli. When somebody says it is a Pochampalli, the people know that it is originated from Andhra Pradesh, a particular area of the. So some products are known for their origin. For example, Alfonso mangoes, it comes from the uh, that this Ratnagiri, Konkan area of the Mumbai. Petha, Agra ka petha, Mathura ka peda, Darjeeling tea. If some tea, Darjeeling tea means it's originated from Darjeeling. So some people, they are originating from a particular place. So then the place is also associated with their name. So they are coming from, so their quality is attributed, and reputation is also there because of the geographical origin. And why they are famous? Because why they have become famous? Because the local climate, because the local climatic condition. See, the Alfonso mango you cannot grow in Andhra Pradesh, or the Pochampalli sari you cannot make in Rajasthan. If you make the Rajasthan, it will be considered as a spurious product, and you cannot sell it. So these things have a inherent characteristic: the soil, climate, territory. They are connected to a particular region. So these things also, this shows basically the geographical origin of the Rasgulla. It comes from Orissa. It is registered. So geographical indication and the trademark has some similarity. Trademark is given for the individual company. Geographical indication is a collective trademark. That means all the people who are manufacturing Pochampalli sari in Andhra Pradesh region, they can use they can use. What is the problem? Hello?
Sir,
No problem, sir.
no problem, sir.
The screen changed actually, so I ask. Screen changed. But my that slide is also gone.
No, sir. Slide is
Slide
visible,
gone.
sir.
To me, it is not visible. How will I move? Somebody done some mistake, I think. Yes. Now it is visible. Okay. So this geographical indication there tells us about the origin of a product. So let us see some of the international geographical indication. The advantage of giving protection to them is that there are some people who sell spurious product in the market by the name of these places. For example, in Delhi, some people are selling Pochampalli sari, some saris by the name of Pochampalli sari. So what is the drawback? What is the um, drawback in this, that the person who buys get a spurious product, and the revenue which is generated does not go to the real people in the Andhra Pradesh who make Pochampalli sari. To stop it, the government has enacted a law for geographical indication, and they have registered these products which are originating from a particular place. The advantage is that here the trademark, that trademark is for individual company. Geographical indication is the collective trademark. I told you that all the people who are making Pochampalli sari can use the word Pochampalli for their sari, provided they are the member of the association. The mark is given to the association. Suppose there are 1,000 weaver in Pochampalli area and 900 are the member. So rest 100 cannot use Pochampalli. Only the 900 people who are the member of the association who has applied for geographical indication can use this Pochampalli trademark. Now you see the Colombian coffee, the France Champagne. Champagne is a sparkling wine, very good wine, which is comes from a Champagne village in France, because they are this grapes is grown there. But it is not only the simple wine. See, there is a process associated with it also. This wine, after making, is kept for 2 years in the bottle for complete fermentation. Then it is sold in the market. So there is a, it is not only the place from where it is grown, because there are 1,000-year legacy. Their forefathers, they were working, they were doing, because these people also do some research. For example, in Pochampalli, there were not those kind of designs. Now you can see the modern design, in Pochampalli, because that is the development. So they have developed, they do R&D work in this geographical indication products also. So the government has protecting these their product, because it is the livelihood of the rural. These things are made in the rural area. So government wants to protect their livelihood, as well as to the buyers like us. We also get the right product, and they also get the right revenue. That is one of the reason. Now you see, there are some more examples of this thing, and this is some more examples you can see. And Darjeeling tea was the first geographic registration given in India for the Darjeeling tea. First geographical condition. It was the first product which was registered under geographical indication in India, Darjeeling tea. Now there are about 250 products which has been registered, and this is for, so all the growers, all the farmers who are growing tea in Darjeeling area, and if they are the registered member of the association which has applied for this registration, they use this. So whenever next time when you want to buy a Darjeeling tea from the market, you must see this logo. This has been awarded by the government of India to them, so that to find the genuinity of the product. See, with the development of semiconductor technology, it has become possible to accommodate thousands of electrical function on a small chip. How they do it? Because it is the arrangement of what is the circuit, what is the chip. On the chip, the electrical components like conductor, like your connectors, wires, and some diode, and all these things, they are placed in a certain fashion in 2 or 3 dimensional topography. So that makes a layout design. How the electronic components are placed on the chip. Each company has its own chip, own design, and those designs are registered with the Department of Electronics. Now they perform certain function also. Now you see, the advantage for this is, because you can accommodate large number of electrical function in one place. That means you have miniaturized. You have reduced the size of the equipment. You have reduced the use of the material. So the things have become cheaper, and they have become affordable because of this layout design. This is also protectable, and the protection is given only for the 10 years. This is just like a copyright, but it is after 10 years you cannot uh, renew this trademark. Sorry, this intellectual property. Now, trade secret is another intellectual property. What intellectual property you want to protect for your idea is a business decision. For example, let us compare a trade secret.
Hello, sir. We are not audible.
Hello, sir.
The
Hello, Sharma,
information
sir.
is kept secret. Yes. Yes, please.
Now audible, sir.
Eh? Hello.
Your voice just hello, sir. Your voice just cut off for a few seconds, sir.
Uh-huh.
No problem. Please continue.
Okay. 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 So, so what intellectual property you want to take? It is a business decision. Yes, in educational institutions like yours, because the teachers they get glorified. For example, if somebody has 8 or 10 patents, for example, if you want to apply for IIT nowadays, IIT people they want the teacher should have patents. But particularly international patents or Indian patents, they should have patents there. So for your glorification, for your career advancement, this is good, but industry cannot afford, because industry all these intellectual property you have to invest money in it, and the industry see that how much money they are able to recover by protection of certain idea or certain technology. So that is very important for the business. Yes, for the education institution it is not. And I want to tell you only 2% of the patent in the world sees the light of the day. 98% of the patent has never been commercialized. Only 2%. So these 98% they help in glorifying your career and CV and in career building. So here I will give an example of Coca-Cola. See, Coca-Cola is a company which was in America and Florida, and by a government order of the state provincial government that all liquor manufacturing should be stopped. They asked the Coca-Cola company to stop manufacturing beer. Now there were two options with the company, either to close down the factory or do something else. So what they did, they found a formula of Coca-Cola. It's a very good formula, beverages. Now they decide, they thought whether to go for a patent or to go for a trade secret. If they go for a patent, the patent has a life of 20 years. After 20 years, the formulation will be in the public domain, and there will be many manufacturers of Coca-Cola in the world. I've traveled to around 50, 60 countries, and I've seen the Coca-Cola same everywhere, same face, same color, same taste. So what they did, they thought that let us have it as a trade secret. That means they will keep it secret information. And see, you're surprised that for last 125 years, the Coca-Cola formula is being kept separate, is being kept secret, and it is only known to two people at a time in Coca-Cola company, and these two people are never allowed to travel by the same transport in same direction, because if some accidents happen, the both will die and the formula will also go with them. See, now the Coca-Cola has been able to protect its business only with trade secret and the trademark. You see the trademark of the Coca-Cola is a trademark. It has only two intellectual property. One is trade secret and a trademark. This trademark, the bottle is also trademark. You can register the design of your product also as a trademark. You see the bottle. This bottle is the shape of a woman. This bottle is the shape of a woman wearing a skin tight dress. So see that this bottle and the trade secret by these two, they have been able to keep their business running for the last 125 years. The protection of plant varieties. See now the hybrid seed has come in the market. So hybrid seeds can also be protected. Hybrid trees, hybrid seeds, they can also be protected by a new act which is called protection of plant varieties, and this can be protected for 20 years. And the condition for them is the hybrid seed should be novel, it should distinctive, stable, and uniform. If it qualifies these conditions, then you can protect the plant varieties also. Now, the one more intellectual property, that is utility model, which is the law for which has not been enacted in India, but in some other countries it is there. It is the small brother of invention, patent. It is just like a patent, but it is not when you submit an application for utility patent, your application is not examined very rigorously. They just see casually, they see, and if they find something good in your application, they can grant you the utility model. We have studied industrial design. This is also a design. utility model is a functional industrial design. The earlier industrial design was only the appearance. Here it is a design, but it must function. For example, I showed you the hug chair. The hug chair could have been protected in industrial design as well as the utility model because it performs that function. So now you can understand the life, the protection is shorter. That is for 10 years. It is distinct from industrial design in the sense that it is a functional design. It does some work. Let us understand with the help of the example. This is a jerry cane. The jerry cane, you can take water into jerry cane, but lifting and carrying is difficult. So what they have done, they have made certain improvement, some incremental invention they have done. They have put two casters at the bottom and one adjustable handle. So dragging is easier than lifting. So it will go under utility model because it will not go into patent because not is a very big invention. So therefore it can go under utility or utility patent. In America it is called utility patent also, and utility model also it is called in some countries. So like this it is can go. Better example I can show you that we have our suitcases. When we travel we carry our suitcase. In my time there was no wheel in the suitcase. I used to lift and keep it on my shoulder or my head, and then I have to travel. Now thereafter a suitcase came with this kind of two caster and one adjustable handle so that I can drag them at the railway platform. Now you might have seen that suitcase have come which is called a trolley that has got four wheels. All the four move 360 direction, and you can take along this trolley with you. No need of dragging also. As you move, the trolley goes along with you. So these kind of small interventions in the technology, and these small interventions can be protected as utility patents. Now let's understand with the help of this how many intellectual property you can have a product. So intellectual property whatever possible. How many intellectual property? Suppose somebody is manufacturing a watch. So with how many intellectual property he can protect his product? So you can I just generally give this example. You see the watch and it is in JCWA. So JCWA is the trademark of this watch, and I can protect it with the help of trademark right. Now you see the watches, they are circular, but he has put contours in it. He's changed the design. Instead of circular, it has some contours type of thing. So this can also be designed. They registered. This can be registered as a design right. This can. Now you see, you make a mechanism in the machine. Suppose you make some improvement in the machine, some mechanism inside this machine, which improves the precision and accuracy of this machine or this watch, that can be protected with the patent right. And this inside of this watch. Generally, what happens? This button is used to adjust the needles of the watch. Generally, you have seen that somebody has to drag it out and then move it clockwise and anti-clockwise to adjust the needle. But here he developed a button that you keep on pushing that button, and the needles is keep on going moving, and you can adjust with the help of this push. It's not a very big invention, so it can be protected under utility model right. And you know, with all machines, whether you buy a washing machine or a refrigerator or a machine or a testing machine in your laboratory, they come with a warranty card and a user's manual, a instruction manual. The user's manual and instruction manual of a product by a company can be protected with the help of a copyright. Now you see that as much as possible you can protect your product because it's a fencing basically, so that the people cannot imitate it. The copier cannot attack your product. So this is basically, I call this intellectual property as a fencing around your product. So if you have protected by some intellectual property, the up to the life of the intellectual property, your product get protection. Nobody can uh, do it. Now see, in the future, intellectual property is not the money that will run your business. It is the intellectual property which will be the oil of the 21st century. The people who respect other intellectual property, who respect their own intellectual property, and who are very innovative and IP savvy, they will remain in the market. Rest of the people, they have to close down their shop at the end of the day. Thank you very much, my friends. I hope I have been able to get you a summary of, I mean, appreciable idea of all the intellectual property which are possible, which are available for you for protection world over. And I think you have to uh, evaluate your work, your creativity, and see in which category your invention or the creativity fits in. Thank you very much. This is the quotation I have given. The protection of innovation is imperative to techno-economic development. This is by me, and thank you very much for listening me patiently. Thank you.
Thank you, sir. I would like to request all the participants to post their questions either in chat box or please turn on your mics and ask the questions to the sir himself.
Yes, yes, you can ask any question.
Sir, I have a doubt.
Hmm.
Sir, say I've developed some process like
Hmm.
I've developed a process where I can extract caffeine from sports drinks. Sir, I don't
From?
want
You can
sports
extract
drinks, sir.
caffeine
Sir,
from? Caffeine from?
from sports drinks, sir. For fun,
Acha.
I've developed a process.
Hmm.
Let's say, and
Hmm.
I don't want to patent it, sir, because I want it
Hmm.
to be available for everyone. But
Hmm.
I want credit for it for developing
Hmm.
that process. So what should I do?
Yes. You should pay credit only. Say, if you say I have developed this process, nobody will believe it. The people will believe you
Yes,
when
sir.
you have a certificate in your hand. So you
Yes, sir.
allow the people to use your method, but you get it patented. What is wrong in it? For you, it's not very
Okay.
expensive.
So
It's 4,000, just a matter of 4,000 rupees. You pay and get a certificate and put it in your CV curriculum vitae.
okay, sir.
Hmm. What is wrong in it? You patent it and give it free
Yes,
of
sir.
cost to the people. Don't charge for it.
Okay, sir. I was wondering that if we have patented it, nobody can use it
And
until we
I
develop.
advise you, my friend, I advise you, my friend, you must patent it. Because if
Sir.
something new you have discovered, then you must patent it because it will help you in your career. It's not the money. Ultimately, it is not the money that matters.
Yes, sir.
Teachers like you, I think you are a teacher
No, sir.
or
I'm
a
a
student.
student.
A student. So it will help in future. Now I'll tell you a story. Two students came to me from Jalgaon when I was working in the NRDC. And these two students, they did some work on tractors. Now they're mechanical students, and when these people after their completion of their degree, these companies visited the camp. They came in the campus for selection of these students. Now these two students got selected by Mahindra and Mahindra. Mahindra and Mahindra also came, but other people were not got selected. Once they met me in Delhi, I said, "What are you doing nowadays?" Sir, we got selected in Mahindra because they developed something in the tractor, and they came to me, and I helped them in filing. I funded their project in filing. I helped them in filing a patent in India, and they got the registration number. When you go as a student in your final year, when campus come to your school, they will call you. So they will call you. They will ask you questions. They will see your CV. If your CV is simply BTech Mechanical Engineering, they have a lot of scope to ask you. And from entire mechanical engineering, they will ask you questions, and somewhere you will stuck up. When these students CV went to the Mahindra and Mahindra, they mentioned that they have got two patents in the tractor, and because they have done it with their own hand, they know the art, science, and technology of the tractor. So all the questions thrown against to them was based on the tractors, and they knew it, and they were able to answer all the questions, and they got selected. So you must mention it in your CV when campus comes. You must show that I have developed a process of caffeine. They will ask you the question on that. They will forget all your chemistry, all your technology, everything.
Okay, sir. Thank you,
Follow
sir.
me.
Yes, sir.
You
Yes,
must
sir.
patent it. Just patent it.
Yes, sir. Okay, sir. Sir, I would like to request all the participants to fill the form that is posted in the chat box for the e-certificate. Finally, I would like to conclude this session by thanking our director, Dr. Shambhu Prasad, sir. Thank you, sir. I would like to thank our vice president, sir. Thank you, sir. I would like to thank our principal, Dr. K. Satyanarayan, sir. Thank you, sir. I would like to thank the vice principal. Now, I would like to thank the resource person, Mr. Govind Sharma, sir, for sharing your valuable information and knowledge with us. Thank you, sir. I would like to thank our coordinator, Dr. Shubhot Panda, sir. Thank you, sir. I would like to thank all the faculty
You share
coordinators, faculty members, technical staff,
you share the feedback with
student
me.
coordinaters. Okay, sir.
You, sh-
Will do, sir.
you share the
Thank you,
feedback with
Vanita.
me. It helps me in improving my lecture. Okay.
Okay, sir.
So
Sure thing.
thank you very much. God bless you all.
Thank you for being here, sir.
Dear participants, fill the feedback link which is posted in chat box.
Those who filled the forum, you can please leave. Thank you.
Okay, after filling the feedback link, please left from the group, left from the meeting.
I think I have done some of the things. I will tell you